Celebrate with me. Hey guys, in our last video, I shared with you 3 things that you should be aware of if you have a merits hearing before an immigration judge while you're detained. And in that video, we talked about 3 policies that the administration has put out that I actually encountered. Well, in this video, we're going to talk about the actual merits hearing case that I had with my client, which was on a detained docket. Detained docket means that the client is in detention and the trial is taking place while they're in detention. Now, first off, let me just share with you that the particular application that we represented our client with was cancellation of removal for a non-green card holder or non-lawful permanent resident. And so what is this? This is a type of relief or defense that someone can apply for if you're in immigration court. There are specific eligibility requirements that you do have to meet, but if you meet those eligibility requirements, and the judge finds favorable discretion in your favor, this is a pathway for you to remain in the U.S. and obtain a green card. Now, let's go over briefly the eligibility requirements for a cancellation of removal for a non-lawful permanent residence. First off, you have to have 10 years of continuous physical presence, which means from your last entry in the country, you had to have been in the U.S. continuously for 10 years. Secondly, you have to have qualifying family members, such as a wife or child or children who are U.S. citizens or green card holders, who would suffer extreme and exceptionally unusual hardship if you were to be deported to your home country or a third country. And lastly, you have to show good moral character. Now, if you are someone who maybe has had some sort of criminal law enforcement encounter, you're also going to have to show that you are someone who is reformed, changed, and has been rehabilitated, because that is going to be something that the judge is going to want to know. Now, in my client's particular case, just to add more detail, my client did have a criminal law enforcement encounter. And so that is something that we had to address within the trial. Now, here are some things I want you to be aware of that could come up during this type of particular proceeding from the government attorney. Many individuals who have been here for quite some time, but maybe don't have a pathway without leaving to consular process, maybe such individuals already have an approved I-130. One of the things that you should know is the government attorney may very well ask, if you do have an approved I-130, couldn't you just consular process? Well, if you've got extreme and exceptional unusual hardship to your family members, consular processing would separate you from that family member or family members. And so that may not be the best option, because that would put your qualifying family members in a worse position. So be aware of that. Another thing that you should be aware of, many individuals, depending on whether or not they had a work authorization and a social security number to file taxes, or whether they knew that they could apply for a I-10 number in order to pay for file taxes. Some individuals may not have paid taxes for a portion of the time that they've been working, or not at all. You need to be prepared to address, moving forward, how will you correct that? And if given the opportunity to remain in the U.S., that you will in fact pay taxes, because that is an indication that you are someone of good moral character. Another thing to be aware of is that the government attorney may ask you certain inadmissibility questions from the I-485. So you want to be aware in preparing for your hearing, if you have filed a cancellation of removal for non-green card holder, You want to be prepared in going over the questions listed on the adjustment of status application that pertain to inadmissibility. And so these are some of the tips and strategies I wanted to bring to you guys. If you are someone who may be applying for this form of relief, or if you have a case or a loved one, I should say, coming up, and you want to be as prepared as possible. In our case, as I shared with you in the prior video, all three of those policy issues we did encounter. Uh, the court did stick to a very strict benchmark in our case. The request for a continuance was not granted, and the government attorney did move to pre-termit, although it was not an asylum application. And so, with encountering all of those issues, we were prepared in advance to be able to address. What do I mean by that? If you file a motion for continuance, you have to continue still preparing as if the motion for continuance will be denied. So you've got to have your backup plan. And that goes along with understanding right out of the gate that these cases are going to go fast. So you have got to move fast with working with your attorney. With regards to the pre-termission or motion to dismiss that the government attorney may ask the court to dismiss right out the gate, you've got to be able to, while working with your attorney, identify what areas that are susceptible or that the government attorney may try to argue is the legal reason to dismiss. And you've got to be prepared to have your response while working with your attorney to argue against that. Guys, all in all, with the three policies that we encountered and with rulings from the court that were not favorable as far as the motion to continue, in spite of it all, with the strategies and tips that I've shared with you, we were able to successfully prevail with regards to the application for relief that we represented our client in immigration court. And so I do want to say that obviously that this result is just an example. It does not represent what someone else's result could be. This is really just for case study purposes and entertainment purposes, and it is not legal advice. But I do want to stress to all of you, you should absolutely work with a licensed immigration attorney and just be aware of the different things that are happening in these merit hearings that you should be aware of, particularly if there is a form of relief that you are seeking that will lead to a green card. So I do thank you so much for watching. Thank you so much for celebrating with me. And I will definitely see you in the next one. Bye-bye.